My name is Aaron Rosenblum. I'm the Engagement and Education Coordinator at the ACLU of Maine. Delighted to welcome you tonight to our webinar, Notes on the Votes, the 2026 legislative session in review. We've just concluded the 132nd legislature, and tonight you'll hear about our victories in Augusta, the implementation of new laws that were passed, and the work that remains ahead. First, I will talk briefly about our work, and then I will hand it over to our policy team. And then at the end, we'll have a Q&A. There's a Q&A tool you should see on your screen. You can drop questions in the Q&A at any time as they occur to you, and then we'll try to address as many as possible at the end of the presentation. I've already introduced myself, Aaron. I'll be joined tonight by our policy director, Michael Cabetta, and our policy fellow, Alicia Ray. So, for those of you who might not be familiar, the ACLU of Maine is active in the courts, the State House, local government, and communities throughout Maine, where we defend the U.S. and Maine constitutions and the Bill of Rights, and work to protect and expand the civil liberties of everyone in Maine. We do that in the courts through cases like Trump v. Barbara, the case that we just argued in front of the Supreme Court. We do that in Augusta and in towns through the policy work you'll hear about tonight from our policy team. And the community part sometimes looks exactly like this, a webinar with you, or when we're out in community at pride festivals and other events, and through sharing of information like our Know Your Rights information. So if you want to learn more about our work or just keep up with our work, you can get on our mailing list. If you're not already, it's right on our homepage, as you can see there, the sign up. You can visit aclumaine.org and do that. You can get email updates. You can explore the rest of the website, which I'll go into a little bit, and you can follow us. We're at ACLU Maine on Blue Sky, Facebook, Instagram, and Twitter. Also on our website, there's a Take Action button, and you can follow that to contact legislators based local, state, and federal. You can support our legislative priorities, learn more about the process, and you can sign up to volunteer from that page as well. And you'll hear about this later, but even while the legislature is not in session, there are still ways to take action and to make meaningful contact with your representatives. Very important on our website, though not the core subject tonight, there's a Know Your Rights section, and it's never been more important to know your rights under the Constitution, the state constitution, state law, federal law, and that's at aclumaine.org/know your rights. We have information on ICE encounters and law enforcement, on students' rights, First Amendment rights, and a lot more. I learn new things every time I visit the page. And it's also updated a lot, but I just learn new things because I don't retain all of it every time. So visit that and please spread the word about all that rights information. You can also find events on our website. We have a lot coming up in June, which is Pride Month. We will be at Ogunquit Pride on June 6th. The next day will be a Great Falls Pride in Lewiston, Auburn. Interrupting the Pride theme, on June 17th, if you're in the Boothbay area, our legal director, Carol Garvin, will be presenting on immigration rights and kind of everyone's rights when encountering immigration agents and when protesting or documenting those encounters. And then on June 20th, we will be at Portland Pride, both marching in the parade and tabling, which is what we'll be doing at the other one. So come visit us if you're at any of those events or around Boothbay. And you'll find all that at aclumaine.org/events. And of course, there is a donate button on our website, and you can support us in a number of ways. You can join the ACLU, you can give directly to the ACLU of Maine. Every gift helps us do this work and more than even what we'll talk about tonight. We don't receive any government funding, which is good because our government funding can't be cut. But it also means that we rely on supporters like you to do all this work. So with that, I am delighted to hand it over to our policy team, to Alicia Ray, our policy fellow, to get us started on what you came here to hear about.
Thanks so much, Aaron. Hi, everyone. Thank you so much for joining us on a record-breaking heat day. I'm sure everyone is trying to cool off, but Let's talk about why we're here, what we're actually recapping tonight. The 132nd legislature actually started back in January of 2025 with the first regular session. And what we're talking about tonight is the second regular session, or as we affectionately call it, the short session. This short session wasn't all that short. It ran from January 7th until April 15th. And then the legislature came back in for a veto override day and finally adjourned on April 29th. So just a few short weeks ago. In the short session, only bills that were carried over from the long session or emergency bills are going to be heard. And when we're talking about carried over bills, those are bills that were introduced during the long session, but not fully dispensed with. The legislature didn't have time to go through the entire process and get to work sessions or floor votes, or maybe they did go through that entire process, but maybe they got left on the appropriations table that we'll talk about a bit later. And emergency bills are heard as well. Those are bills that are proposed after the long session ends, and those are special bills. They have to be approved by the majority of the Legislative Council, which is the leadership of both bodies. And then they go through the normal process of public hearing, work session, and chamber votes as well before they head on to appropriations and or the governor's desk at some point. And so those are bills that there is a real emergency to enact them. So those ideas come up later. You've heard Michael and I talk about this process before. If you've joined us before, committees are assigned these bills. They have those public hearings where it's the opportunity for you all and for advocates like us to participate. Sometimes us advocates are invited back for work sessions to share our expertise, and the committees work those bills. And then the committees vote, and the bills head down to the chambers for additional votes and then on to the governor's desk. But a key aspect of this short session that happens every short session is that it is an election year. And that has a real impact on what can and cannot get done. And in particular, this year, we have a big gubernatorial election at play. So this is going to impact legislators' relationships with each other, lobbying relationships, basically everything that happens in Augusta for the session. So we're going to next talk through some key victories we obtained during the short session and some of the progress we made carried over from the long session. As we talk about these victories, the general effective date to keep in your mind for bills from this session will be July 29th of this year. And I'll pass it over to Michael to start us off.
Thank you, Alicia. Thank you, Aaron, for that introduction. And thank you all so much for joining us on this beautiful evening. I'm Michael Cabeda. I'm Policy Director at the ACLU of Maine. The first bill I'm going to talk to you about is LD 1971. Some of you might have read about this bill. It passed both chambers and landed on the governor's desk last year, in the middle of last year. The governor didn't sign it, but she didn't veto it. The goal of LD 1971 is to disentangle state and local and county law enforcement from ICE and Border Patrol. You're all familiar with the widespread abuses of constitutional rights that the federal government's immigration crackdown has meant, and this bill was one of our answers to that problem. You will all remember that the governor didn't make up her mind about this bill until December 15th of last year. She had a chance to veto it. She didn't. In ordinary circumstances, if the bill had passed with more than 10 days in the legislative session, it would have gone into effect without her signature. But that wasn't the case. We only had 6 days left in the session. And so this bill, as Alicia said, will take effect in July 29th of this year. And one of the things it would do is prevent most local police officers, most local police departments from helping the mass immigration effort. Now, we have a website, a webpage on the ACLU of Maine website that is a compilation and summary of documents we've obtained through public records requests from over a dozen police departments throughout the state. There are a couple of stories from those records I'd like to share with you now, just to give you an idea of what's going to be illegal once this law goes into effect. For instance, in Waldo County last March, an officer pulled over a car for speeding, and the officer learned that the driver's license had been suspended and called dispatch. Dispatch told the officer that driver was an immigrant. And then the Waldo County Sheriff's deputy called Border Patrol. Border Patrol came and took one of the passengers in the car into custody. There are stories like this from Caribou, Brunswick, Ashland, really all over the state, Oxford. And some of these stories actually happened late last year in October, November, and December. And so if this bill, LD 1971, was law by last fall, some of these handoffs between local police and Border Patrol or local police and ICE would have been illegal. Now, during the period when we didn't know whether the governor would veto this bill or allow it to go into law, we decided to try and pass similar legislation at the local level. We went around the state, starting with Rockland, Maine, convincing city councils to pass their local versions of LD 1971. And we were successful in that effort, starting with Rockland, and then in Lewiston, and then most recently in Portland. Bangor and Waterville are weighing these ordinances as we speak. These ordinances are actually, in some respects, stronger than LD 1971. LD 1971 restricts only law enforcement, whereas these ordinances that we've passed at the local level with the partnership and help of elected officials, of counselors, they restrict not just law enforcement officials, but also civilian officials, people like election clerks or shelter workers. The reason it's important to restrict non-police public employees from cooperating with or helping Border Patrol and ICE is that we've seen the Trump administration use every means possible to grease the wheels of its mass deportation agenda. For example, the Trump administration has requested voter roll data from the Secretary of State. The Secretary of State is not a police officer, and the employee of hers from whom the federal government requested that data is not a law enforcement officer and wouldn't be regulated by LD 1971. But at the local level, election clerks handle lots of sensitive information about voters. There are other types of city officials that interact with non-citizens and have data about non-citizens. For example, school employees or someone who works at a shelter where some of the people taking shelter there might be non-citizens and might be targeted for immigration enforcement. And so these local ordinances are already in effect, with the exception of Portland's goes into effect 30 days after enactment. It was enacted just a few weeks ago. But in Rockland and in Lewiston, this has been law for months now. Another piece of legislation that is sort of a companion bill to LD 1971 is LD 2058. LD 2058 was sponsored by Senator Talbot Ross, and the goal of LD 2058 is really to clarify a law that the Department of Corrections and Maine sheriffs had concluded in the middle of last year, obligated them to receive and hold anyone brought to them by any federal agency, including ICE and Border Patrol. And so if ICE comes to Cumberland County Jail or Two Bridges Jail or Androscoggin County Jail, the DOC and the sheriff's position was they have no choice but to hold and detain that person in their jail. This interpretation of law, we felt at the time, was incorrect. It was a misinterpretation of the law. But based on that misinterpretation of the law, Cumberland County Jail, other jails in Maine, were holding dozens of non-citizens for ICE. And so, working with Senator Talbot Ross, we lobbied, and passed this bill, which ultimately even Sheriff Kevin Joyce ended up supporting. You'll all remember Sheriff Joyce's Bush League moment from earlier this year, after one of his corrections officers was detained by ICE, arrested and detained by ICE. And the conflict between him and the federal government led to the federal government removing all immigrant detainees from Cumberland County Jail. And so perhaps as a result of that, he became an ally on this effort. And this piece of legislation, which was signed by the governor in April, clarifies that Maine jails have no obligation to hold federal detainees that are facing civil immigration charges. And so read together with LD 1971, LD 2058 means that local jails can't honor, would be illegal for local jails to honor what are called ICE detainer requests, or which are essentially when someone is free to go from jail, ICE or Border Patrol will call the jail and say, hold that person for us for X number of days or hours until we get there. We felt that that was illegal under Maine law to begin with, but now LD 1971 and 2058 together make that clearly illegal. Another piece of legislation sponsored by Senator Jill Doosan is LD 2176. We worked with Maine Equal Justice and other nonprofits to pass this bill, and this bill essentially prohibits landlords from sharing confidential information about tenants with anyone, and confidential information is defined to include immigration status. This bill, we believe, will help protect some immigrants from being deported if their relationship with their landlord breaks down, or if their landlord, for whatever reason, doesn't want them to be a tenant anymore. And maybe it's easier to have them deported than to have them evicted. And Alicia will take the next one.
Thanks, Michael. So we just talked through new key protections for immigrant rights with LD 1971 and law enforcement interactions, with LD 2058 and jail detainers, and LD 2176 and tenant protections. Now we turn to LD 2106, which covers public health and public education. And we called this our sensitive locations bill throughout the session. Why is that? So the federal government used to have a policy administered through the Department of Homeland Security, but the federal administrations over time, bipartisan administrations, used to tell the Department of Homeland Security that there were certain locations, sensitive locations, where it was inappropriate and just reckless to enforce civil immigration offenses at those locations. And those were public schools, public health facilities, and places of worship for the most part. Those policies changed a bit over time, but that policy was fully rescinded as of January 2025. It was not rescinded during the first Trump presidency, but during Trump 2.0, that is what happened. And since then, we have seen enforcement increase at those sensitive locations in Maine. You may recall a news story from Portland in September of 2025, where a parent was picked up by nameless agents while dropping their child off at Talbot Elementary School, and that demanded state action. So Representative Ellie Sato of Florham introduced LD 2106 as an emergency bill, and it was approved through Legislative Council to be heard during this short session. During the public hearing, the Judiciary Committee heard from all sorts of entities asking for guidance on what to do and what their rights were. And what we ended up with is a bill that directs the Attorney General's office to issue guidance to those entities. There is mandatory guidance that public schools, public libraries, and state health institutions need to adopt within 60 days after the bill goes into effect. So after July 29th, there will be a timer that starts for the AG to issue the guidance and for those entities to adopt that guidance. And then there's also this really cool optional part where The AG's office will also issue optional guidance to those other entities that asked to be regulated as well. And so hopefully this starts to create a more standardized and uniform system of guidance in the state of Maine for those types of entities. And generally, all of this is going to amount to the fact that employees at, volunteers at, any administrators at these public schools, public health facilities, and public libraries can only allow immigration officials to enter their non-public areas or see confidential records if they have a valid judicial warrant. So we are not accepting administrative warrants in the state of Maine at those facilities. The governor signed this bill into law. You can see from our photo, there was a signing ceremony. And we are looking forward to seeing the AG's office develop those pieces of guidance, those opportunities, hopefully for training, so that everyone in the state of Maine is on notice of what their rights are. Our next victory moves out of the immigrants' rights space and into our criminal legal reform space. LD 2059 expands access to legal counsel. And this was an emergency bill in the sense that it was introduced during the short session, but it also had something called an emergency preamble, which means it would immediately go into effect after passage, but that means it requires 2/3 passage through both bodies of the legislature, which meant it needed bipartisan support. So for some background, you may have heard of the ACLU of Maine's litigation in the Robbins case, which is still pending before the Maine Supreme Judicial Court. And we're waiting for the Supreme Court of Maine to tell us what their opinion on this case is. However, we do have a trial court decision from the Maine Superior Court. And that case was decided in the ACLU of Maine's favor and concluded that the state has violated its constitutional obligation to provide lawyers for criminal defendants. This bill represents a part of trying to meet the state's obligation there. The state mostly relies on private contract attorneys to represent criminal defendants in cases it brings, and then it reimburses those private attorneys. However, there was a large projected funding gap in this reimbursement funding for the current year. This bill funded that shortfall, and it also created the Casco Bay Public Defender's Office, which will alleviate some of that burden on those private contract attorneys by taking about 30% of the caseload for Casco Bay area. And it passed both chambers with the 2/3 votes needed to go into effect immediately, which is really something in this political climate. And so this is a great effort that really sets us up for a start to address the issues that have been raised by the Robbins case. And we've talked a lot about new laws that we've passed, but sometimes the ACLU of Maine is on the defensive. And this session, we worked to defeat a bill, LD 1457. This was a carryover bill, so it was introduced in the long session, had its public hearing in 2025, but work sessions and votes happened this year. The bill itself proposed a pilot program where the Maine Turnpike Authority would have been allowed to place 3 speed cameras on the turnpike over the next 3 years as an exception to Maine's current general prohibition on automated traffic enforcement. The ACLU of Maine opposed this bill, and we oppose any technology that will lead to the government acquiring data about our movements. While these cameras capture a moment in time, when these images are aggregated together, they can show a really telling picture of a person's life, which doctor they go to see, where they worship, what protests they might be attending. And we had so many great conversations with legislators throughout the session and then received overwhelming bipartisan support in defeating this bill. So we have won the battle for now. And I know you might be thinking, we've defeated the speed cameras in the 132nd legislature, but what is going on with Flock in the state of Maine? I get a lot of questions about that. and not just flock, automated license plate readers in general. We haven't seen anything at the state level yet, but I can tell you for sure in towns and cities across Maine, this technology is being marketed aggressively to police departments, mostly in processes that receive no public input intentionally. We at the ACLU of Maine have been looking into this issue, and you can learn more about what our Freedom of Access Act requests have revealed on our website. I'll pass it back to Michael to talk about some places where we made some progress this year.
Thank you, Alicia. We didn't win everything we worked on in 2026 and 2025. And one of the biggest setbacks that we experienced was in our effort to pass a data privacy bill. We came further than we've ever come in passing this piece of data privacy legislation, but we were vastly outgunned. The lobbying resources poured into this effort by the tech industry were overwhelming. If you look at the screen, you'll see that LD 1822 was far and away the most lobbied bill in terms of dollars spent on legislation, the most lobbied bill in the state of Maine in the last 2 years. The next most lobbied bill is the budget, and the budget is the biggest piece of legislation in the legislature. The budget garnered about $50,000 of reported lobbying dollars. LD 1822 garnered 201,000. And so 4 times as much lobbying on that bill as the next bill. Why is LD 1822, why is a data privacy statute important and necessary? Because the business model of tech companies right now, for at least a decade and a half, has been to monetize our data and to collect as much information as possible about us in order to predict and shape our future behavior. The predicting and the shaping of our future behavior is done for literally anyone who'll pay for it. That's not just advertisers looking to sell products or services, but also people interested in manipulating elections, people interested in spreading disinformation. That's happened in the United States, as the Cambridge Analytica scandal uncovered, and we think will happen even more. With the advent of AI, all the data that's being collected about us by every single tech-connected device in our life is being analyzed and turned into a model of our behavior and how to manipulate us by extremely powerful artificial intelligence tools. A big reason why we care about this issue is that the Fourth Amendment to the U.S. Constitution restrains the government from searching us and from gathering data about us without a warrant. But when this data is available through data brokers, which are tech companies whose business model is to buy and to sell data, when that data is available for sale in the data marketplace, the government doesn't have to abide by the constitutional requirement for a warrant. And so right now, thanks to what tech companies have done, the Fourth Amendment is for sale. And if you're a government agency interested in obtaining information about my location, about what I watch on TV, about everything that's in my apartment, then you might not have to go to a judge to seek a warrant to get that information. So if you do go to a judge, you'll have to specify the basis for seeking this information. You have to have reasonable suspicion that I'm violating the law, that I'm committing a crime. But right now, with all the data that's available about us from data brokers, the government can do an end run around these constitutional requirements. And so we spent a lot of time trying to pass this bill, and we were almost successful. The bill passed through the 2 chambers a total of 5 times, 3 times in the Senate, twice in the House. We lost 5 supporters in the House in the final round of voting. And as a result, the bill died. We continue to be interested in data privacy. This is not a fight that we will easily back out of. We will come back next year smarter and better organized. And we encourage any of you interested in this to please help us.
Pivoting back to our criminal legal reform work, I'm going to zoom us way out of this bill real quick. So, the right to a speedy trial is guaranteed in both the Maine and US constitutions and is essential to our system of innocent until proven guilty. And ultimately, it is the government's responsibility to provide a fair process for everyone who it chooses to charge with a crime. And that fair process includes speedy trial rights. So, LD 340 is legislation that would have taken this constitutional right and created statutory guidelines for the government to follow, along with remedies for when the state violated those guidelines. This bill had a lot of success last session. It received both. I'm so sorry. It received support in both chambers. So in the House of Representatives, it passed. In the Senate, it passed. It was enacted. And then it went to the special appropriations table, which I mentioned earlier, and I'll give a little bit more detail about now. So the special appropriations table is where any bill that needs funding goes and is held until the end of the session. It gets held there so that every bill can have its chance to pass or not pass and make it to the table. And then legislators who are on the appropriations committee kind of have a pot of money to work with, and they know what that amount is, and they only have that much money. So they kind of need to Tetris together what they are going to fund, what we call, quote, off the table. So even though this bill had a successful vote out of committee, successful votes on both of the chamber floors, it got to the Appropriations Committee and it stalled out and it stayed there, which means it died upon adjournment due to the Appropriations Committee not funding it. It is great progress that we got that far. It's the furthest we've gotten on this right to a speedy trial, this statutory right. And so we will continue to work on this in the future, of course, and try to establish those statutory guidelines and to hold the government accountable for when they choose to bring people to trial. But this is where this bill ended up this session.
For years, the ACLU of Maine has been interested in strengthening and expanding the state's system for sealing criminal records. The reason it's so harmful, so damaging to have criminal records that are unsealed is that when you receive a sentence for your crime, that sentence is supposed to be the beginning and the end of your punishment. You do your time in jail or in prison, community service, and any other requirements a judge might impose. And then once you're done serving your time, paying your debt to society, you should be able to move on with your life. Unfortunately, criminal records make this impossible for hundreds of thousands of people. And so for years, we've been trying to strengthen Maine's system for sealing these records. This session, we supported a number of bills to do just that. And Senator Talbot Ross's LD 1911, which would have established an automatic sealing record for adults. We already have an automatic sealing record for juveniles, but an automatic sealing system for adults. That bill passed through both chambers, and the governor vetoed it. That's the furthest progress we've made at passing that type of legislation. And we're hopeful that similar legislation next year or the year after will pass with the governor's support. Some of you might be thinking, how do I help? Well, when the legislature is in session, you can certainly be part of our work by contacting us about how to influence your legislator, finding out where they are on our issues. But when the legislature is not in session, you could still contact your legislator. They're still your legislator. They will if it's between long and short sessions, be thinking about the bills that are coming up in the spring. Or if they're after the short session, they might be thinking about re-election and what their platform is going to be. And so it's always good to get to know your legislator, contact them, talk to them. I'm always amazed at how easy it is to find, to contact, and to influence your legislator in Maine. We have a citizen legislature of, generally speaking, not professional politicians, very, very accessible people. And then if there's any bill here that I've talked about that's caught your attention, go on the legislature's website and find out how your legislator voted. And if they voted the wrong way, then take them to task. And finally, visit our website and do what Aaron said at the start of this presentation: volunteer, sign up for our newsletter, and you can always donate and help our work that way. Thank you all so much for listening. I will hand it over to Aaron to moderate any Q&A.
Yes, hello, and I've made it so we don't have to look at a big screen that just says the word questions. We can all be together, sort of, and face-to-face, sort of. As a reminder, there's a Q&A button, and you can drop your questions there. We have a couple already, but keep adding them, and we'll sort of keep circling back to the list. So the first one is asking whether LD 2058 and 2176 are effective already. And also the person was surprised to see the Senate President's yes vote on 1457 and wondered if you had any comment on that.
So the effective dates for the two bills, 2058 and 2176, will be the general effective date, which is July 29th, 2026. So not in effect yet, but it's coming soon. And I would encourage you to reach out to Senate President Daughtry about her vote on LD 1457 and ask her reasoning behind it and lobby her to come to our side on it.
Great. We also just have a person asking what the LD number was on the data privacy bill. I know this one. It's LD 1822, which will be useful in looking up how they voted in the past, and maybe speaking to your legislators about what happened this session. But I'll pass it to Michael and Alicia to give any more detail, if necessary, on the fact that the numbers all change. So if there's a similar bill to this next session, it will have a different number. Yeah, any more to say on that? Is there a way of finding what the next version of a bill is, other than coming to some webinar we might host at the beginning of the next session?
Email us around January.
Great. Yeah, and I had actually a follow-up question from me on that is when when can legislators start filing bills? So when, which is also when can people start looking and seeing what's getting filed and how?
In the period between when they're elected and when the legislature starts, about December. In late December, early January, a list of requests for legislation will be published by the legislature's website. Maine has an unusual system in the United States where any legislator can sponsor any number of bills, and any bills. In fact, legislators can sponsor the same bill. 30 different legislators can sponsor the same bill. I've seen that happen a couple of times. Not quite 30.
You mean file 30 versions of the same bill rather
Correct.
than people signing on, right?
Correct. And sometimes the bill numbers just get assigned sequentially and the legislators work it out among themselves. And so to find out a list of what bills are being proposed, or at least the bill titles, keep checking the legislature's website. You could sign up for the listserv. I would caution you against that if you want to protect your inbox, but you can do that and you'll get an email link to first the list of requests and then the LR numbers, LR being legislative request, and then you'll get a list of the LD's legislative document um, where once the bills have been published, once the language has been added to a document, it'll be posted on the legislature's website.
Great. We have, yes, and we have somebody reminding us just that when you are leaving a message for a representative, they tell you to provide the LD number. So indeed, it can be important to note these down. And Alicia has posted in the chat the bill directory link and where that will be. And I guess that's a sort of a static link. So you could go to that in January and it'll still be the same link.
For the 132nd, that is a static link. There will be a new one for the 133rd.
Okay.
But as bills get printed, they add per day. So you can see them as they roll in from OPLA.
Great. We have a question about how new legislators can contact the ACLU of Maine to work together on legislation. And I'll just add to that, if you wanted to comment a little more about what that even looks like when we work with legislators on legislation.
We've worked with legislators on legislation in so many different ways. I'll cover just a couple. I'll cover three, let's say. One potential path is we have a bill idea, and we're thinking of which sponsor might be the most appropriate sponsor. Maybe that bill we expect to end up in the Criminal Justice Committee. And so probably one of the chairs of that committee would be the best lead sponsor. And so we will go and talk to that chair about that bill, and the chair might agree. If they agree, we'll write the bill for the chair, and then the chair and we will sit down to think about who it makes the most sense as a list of co-sponsors. And then all those co-sponsors become people who work on the bill. And so we end up working with legislators on bills that way. Some other times legislators come up with bill ideas on their own, or they get ideas from elsewhere and they sponsor a bill, and then they reach out to us and ask us to help them. And so we do that. Not always, but often. Other times, a legislator will sponsor a bill that we don't like, or that we have some problems with, but that we generally support. In that case, we'll reach out to the legislator, ask them to explain their intent, their reasoning, and we will explain our analysis of the bill. And believe it or not, sometimes the legislators will say, I'm persuaded, I'll amend my bill to account for your objections, to account for your analysis, and we can work together to make this a better piece of legislation. And so we worked on with legislators on bills in that way as well. There are still more ways, but those are just three. Aaron, you are muted.
Oops, sorry. Did you cover how a new legislator should get in touch?
I didn't.
Okay. Well,
a new legislator can email our info@
great.
email address, and we will be sure to get back to you.
Great. That's info@aclumaine.org, and you can find it easily on our website. It's where most of the contact buttons and things lead to. So we have a question about a bill that was about divestment from a state pension fund. And I think this might offer an opportunity to talk about the kinds of bills. I imagine like there were more than 2,000 bills this session. They were on many, many different topics. So my wild guess, being unfamiliar with this bill, is that the state pension fund is not closely tied to a constitutional rights issue that we would be weighing in on. And so, yeah, what makes us interested in bills? What makes us not able to or not interested in opining?
Yeah, so our personal views aside, basically the ACLU is dedicated to restraining the power of the United States government and of the government of the state of Maine and all of the municipal and county governments in Maine. The actions of the United States outside of the United States, generally speaking, aren't something that we've gotten involved with because a core constitutional right hasn't been implicated. That said, we have, as a national organization, represented Mahmoud Khalil, for instance, who the Trump administration probably targeted because, well, almost certainly targeted because of his opinion on a foreign policy issue. And so National ACLU represented Khalil who was the Columbia University student or a graduate who was living in New York when ICE arrested him. And so in that scenario, we were quite involved in the representation of that person. But the reason we represented that person was because his First Amendment rights were at stake, because the government was taking action against him based on the content of his speech. And so that was a clear example of the ACLU's lane, and that's why we got involved there. That said, even bills that are more squarely within the ACLU's lane of restraining government power, of preventing the government from engaging in content-based discrimination of speech or of people based on the content of their speech. Even bills like that, sometimes we decide not to get very involved in simply because we don't have unlimited resources.
Great. I have a sort of well, first I'll make sort of a not a last call, but another call. If anyone has more questions, feel free to put them in the Q&A. I'll ask just a couple questions, and if there aren't more from the crowd, then we'll probably conclude after that. This is sort of a question, sort of a comment, because I have the power to do it. So LD 2106, that's the Sensitive Locations Bill, covers things like public schools, which are pretty easy to get a sense of, and healthcare facilities, public libraries. Many of the libraries in Maine, many of the things in Maine that are called public libraries, some of them are town departments, which makes them very public and makes it pretty obvious how laws, including these local ordinances we talked about, might control those places. But many public libraries in Maine are the library association of the town of, and they are sort of like doing business as the public library of the town, but that public doesn't actually refer to it being a public entity. So do we know yet whether that will apply? This is many, dozens or even more of the libraries in Maine. Will that come out of the Attorney General ruling? Will it relate to the thing you mentioned, the sort of optional stuff coming from the Attorney General? And I just wanted to raise that for folks who are in many different communities who are attending tonight, who, just so you know that there may be questions about how this is implemented in your public library in your town. I'm a former librarian. I have a buy-in here.
A special interest is asking. Yeah, so LD 2106, public schools, state health institutions, and public libraries, all three of those are defined within their section of the bill. And so it is very explicit who is covered and who is not under those entities. So the Attorney General will also likely include the statutory references as well that we included in the bill. So it should be pretty clear. And if your public library is not covered, encourage them to adopt the optional guidance that the AG is putting out there. I think many library boards would be on board with that, even if they are funded in a different way than what we're talking about here, and they are not municipally run in the traditional sense, and they don't fit under that statutory definition. But yeah, we would highly encourage that you take this optional guidance and maybe you go lobby that folks adopt that as well.
Great. I like that message of lobbying for these protections for your community as a sort of an endpoint. What we have in the Q&A is people thanking us for all the good work. You're welcome and thank you. And again, visit us, aclumaine.org. Come see us at a Pride Festival or at any of our other events. Thanks to Alicia Ray, our policy fellow, and Michael Cabetta, our policy director, for all of this wonderful information tonight. And Michael and Alicia, do you have any parting wisdom or wishes?
We appreciate you all tuning in on such a beautiful evening. I hope to meet any of you who are interested in getting more involved in our work. We can use all the support we can get. As I said during the description of LD 1822, compared to our opponents, we are ragtag and scrappy. And We can only win if all of you are involved and engaged.
Great. Thank you for
Plus
that.
one to all of that.
Yeah. Thank you for that, Michael and Alicia. And thanks to all of you for joining us. And we'll hope to see you soon.